We need to talk about the rule of law. A podcast by Verfassungsblog and Deutscher Anwaltsverein.
We need to talk about refugees and migration law. In discussions about these topics, refugees and migration policy are often being treated as the other of politics and policy. But the way states treat those seeking refuge and asylum on their territory is fundamentally a rule of law issue, and actually says a lot about the current state of the rule of law there. Are refugees able to enter a jurisdiction and apply for their right to asylum? Are due process obligations being observed? Do refugees have access to justice? Does the European migration law system work? This is what we discuss in this week's episode of We Need to Talk About the Rule of Law with our distinguished guests. Marta Pardavi is a lawyer and co-chair of the Hungarian Helsinki Committee, a non-governmental watchdog organization that protects human dignity and the rule of law. Philip Worthington is the managing director of European Lawyers in Lesbos, an NGO providing access to legal counseling in Lesbos. And Maria Karlin is a lawyer with expertise in migration law and member of the Migration Committee of the German Bar Association. She teaches at the University of Passau. I'm Leonard Kochert, a member of Verfassungsblog's editorial team, and I'm happy to have everyone on the show. Mr. Worthington, refugees entering the European Union often do so in Greece, on the Greek islands of Lesbos, where you are right now, or Samos in particular. Please give us a short account of the situation they face there.
Good morning, and thank you very much for the invitation to take part in this episode. So the situation facing asylum seekers when they land on one of the Greek Aegean islands, obviously there is initially the humanitarian aspect, the conditions and the legal process. Just briefly, the situation on Lesbos at the moment is that there are around 10,000 asylum seekers on the island, and the vast majority of them live in the new camp that was constructed following the fire that destroyed Moria camp in early September. The conditions there at the moment, everybody is living in tents and with limited access to showers, toilets, electricity. And whilst there are some efforts underway to improve things, the reality is that thousands of asylum seekers will be living in these conditions over the winter. In terms of the legal procedure, the first thing to say is that there's been a significant change over the past year, partly due to the coronavirus, of course, partly due to changes in relevant legislation that came into force on the 1st of January of this year, and also political events in the first quarter of the year. So just to briefly look at the situation coming up to this year. So from the EU-Turkey deal in March 2016 through to the end of 2019, there remained large numbers of arrivals on the Greek islands, and the legal process was very slow. During this period, it could take up to a year between arrival and interview, and maybe another year before final decision. Whereas from the 1st of January 2020 onwards, the reverse has been true. So the number of arrivals have significantly decreased, and the legal procedure has become much quicker. Indeed, now it's the other extreme, so the procedure is now too quick. This has particularly been the case since the fire that destroyed Moria in early September. At that time, immediately following the fire, all interviews were cancelled, and the asylum procedure was suspended. But when it restarted in early October, the legal process has been very quick. So now asylum seekers are receiving their interview appointments at very short notice, sometimes even only the day before their interview, and there are up to 60 interviews, sometimes more, done each day. Moreover, the interviews appear to be very short, only an hour or an hour and a half sometimes. And this focus on speed undermines access to justice and the rule of law, and in particular, it means that often it's impossible for asylum seekers to speak to a lawyer before their interview, and it's questionable whether such short interviews provide the opportunity for asylum seekers to fully and properly explain their case. Now, ultimately, the asylum procedure is a legal process, but the Greek state doesn't provide any legal assistance or information at the initial stage of the process. Instead, the Greek legal aid scheme only kicks in at the appeal stage. And this is very important, as we all know, because without access to legal assistance and information right from the beginning of the process, many applicants are not aware of their rights and obligations, or even that they have to undergo an asylum procedure. Now, on Lesvos and the other Aegean islands, all applicants must attend an asylum interview, and this is the most important part of the process. So again, no legal aid from the state is available at this stage, and what asylum seekers say on this occasion will determine their application and then follow them throughout the entire procedure. So if an applicant hasn't spoken to a lawyer, it's very easy for them to inadvertently make a mistake or to not disclose something relevant simply because they don't know the relevant criteria and what is important. Now, we believe that access to legal assistance is a fundamental right, and particularly crucial in a situation such as that on the Greek islands, as everything here fundamentally goes back to the legal process. The asylum seekers on the Aegean Islands are going through the legal procedure of applying for asylum, and therefore all the issues that we've seen over the past year, the overcrowding, lack of access to facilities and services, the living conditions, ultimately relate to the legal procedure and its implementation. And one thing that really struck me coming here, I used to work in private practice in London, was that whilst it's absolutely normal for people to have a lawyer for everyday legal procedures like buying a house or signing a contract, what struck me was that on the Aegean Islands, where the outcome of the legal procedure could in some cases be a matter of life or death for people, there were very few lawyers, and most asylum seekers actually don't get the chance to speak to a lawyer before their interview. And just to summarize, what we have unfortunately seen over the past 4.5 years is that the situation in terms of access to legal assistance has deteriorated. The current asylum framework is stricter than ever, and people are receiving their interview dates at very short notice. And this practice, as I mentioned, this focus on speed undermines the right to a fair process and access to justice, and therefore ultimately undermines the rule of law. And recent events, such as the fire that I mentioned, and the corona outbreaks on both Lesvos and Samos and elsewhere in Greece have further eroded legal access still further. So in this context, guaranteeing meaningful access to legal support is more important than ever, particularly as the need remains great. There are only 20 to 30 lawyers on Lesvos and over 10,000 asylum seekers going through the legal process. And on Samos, there's less than one lawyer for every 1,000 asylum seekers. So as I mentioned, the need is very great, and the capacity of the legal organizations to address that need is limited in comparison.
Thank you very much. The odyssey refugees face in the European Union is far from over when they have left Greece. Hungary is known for treating refugees in a particularly horrifying way, with the ECJ ruling that the infamous Röszke camp is a detention facility where refugees are basically held imprisoned. The government's anti-refugee and anti-migration rhetoric is frequently followed by action. Could you tell us more about the situation in Hungary, Ms. Padavi?
Thank you very much for inviting me on this podcast. Hungary is infamous for its vile narrative and aggressive policies against refugees seeking and gaining protection in Europe. But very often the link between asylum and the rule of law is neglected or even avoided, given how extremely politicized the topic of migration has become in the European Union. At the same time, from the ground in Hungary, we've seen how extremely interlinked these two crucial issues are, and how, without addressing the rule of law aspects, there can be no progress in defending the right to seek asylum in Europe. Hungary has, over the past 5 years, completely dismantled its asylum system. And we have now said that it has actually removed itself from the common European asylum system. Over time, without giving you a lot of the details, we've seen how both the right to access to the territory and access to the asylum procedure have become the primary ways to restrict the ability to seek protection. Both of these, access to the territory and access to the asylum procedure, have been restricted through a variety of legal and practical measures. That started in 2015, when Hungary has decided in the summer to build a very high securitized fence at its southern border with Serbia and Croatia, and built up 2 border transit zones, closed container centers to provide accommodation and, in fact, detention to asylum seekers. In 2016, these measures were tightened, and Hungary legalized pushbacks and effectively restricted access to the asylum procedure within these 2 transit zones at the Serbian border. And then these pushbacks, the pushback policy, became a nationwide policy in early 2017 in the spring, when anybody basically who wanted to seek asylum within the territory of Hungary, with very few exceptions, would be removed forcibly, but in what we've considered an extrajudicial way, to Serbia. And so these pushbacks meant that the access to asylum has really narrowed, but at the same time, those who don't have access to asylum in any way in Hungary has really widened. And so the gap between those who have access and those who don't has really widened. Now, after a number of very important judgments from the Court of Justice of the EU that showed that Hungary has built up basically a procedure that is in every aspect unlawful under European and international law, in the spring of 2020, the Hungarian government has basically taken further measures to put Hungary completely outside the common European asylum system. This de facto removal from the European norms has been enacted under the guise of COVID measures. And this is not the only, but maybe the most clear link to the rule of law issue. It's quite well known that the Hungarian government gained the power to rule by decree in March 2020 as part of the emergency measures. And this power also meant that the government basically suspended the right to seek asylum. From March 2020, not one person has been admitted to enter the transit zones. Before that, the number of admissions was gradually, continuously reduced over time through basically practical, non-official measures that we deem arbitrary. But from March, no one has been allowed to enter. Still, there were hundreds of people detained, and it was in May 2020, in mid-May, that the Court of Justice finally delivered its long-awaited judgment that ruled that the detention of people in the transit zone, asylum seekers, is arbitrary, lacks a legal basis in EU law. This was an extremely important judgment, as before that, the European Court of Human Rights came to a somewhat different conclusion. And thousands of people have been detained for months or even years without proper reception conditions and proper access to justice in these 2 transit zones in Hungary. After the judgment of 14 May by the Court of Justice that pronounced that transit zone detention is actually unlawful, the Hungarian government decided to release everybody, all the 280 people who were detained in these 2 transit zones, into open Hungarian camps. But that was basically the only step taken to comply with the judgment. And since then, although more than half a year has passed, no legal changes have been even proposed by the Hungarian government. to comply with the rest of the judgment. So it's important to point out that there is non-compliance with the court's judgment still ongoing, and this is very concerning. Beyond the release of those who were actually detained, the Hungarian government didn't do anything else to ensure that their rights would be respected. Instead, with a government decree, which it had the power to adopt under this emergency legal framework, the government basically declared that the only way to seek asylum in Hungary from now on would be to apply at the embassy, the Hungarian embassy in Belgrade or Kiev. And this is why the whole notion of asylum within the territory of Hungary has been emptied out. Now, this temporary decree is now law, as after the emergency legal framework was over, the Hungarian government proposed and the parliament adopted a so-called transition bill, which further extended these embassy application measures, which are currently in place. And they have actually, by exclusively precluding asylum applications to be launched within the territory of Hungary and reducing this opportunity to be only available at 2 Hungarian consulates in the whole world, the Hungarian government has completely disregarded very basic notions of asylum in the European asylum system. There's no way to apply for asylum in Hungary. In fact, with very, very little exceptions. Even a student who has a valid visa in Hungary that would expire and would, upon return, face persecution in her home country cannot apply within Hungary. She would have to go to Belgrade or be taken across the border fence to be pushed back into Serbia, and would have to apply with a so-called intent to seek asylum at the Hungarian embassy. There is no, of course, legal protection for people in this situation within Serbia. The Hungarian government has not made any measures to ensure that there would be any basic standards of reception for people in this situation. And what we see, the very little practice that we've been able to see, this is this submission of an intention to seek asylum, and the procedure that follows lacks any legal guarantees. From the submission of this statement of intent, the Hungarian Asylum Authority has a 60-day window to take a decision on whether the person would be granted a single entry permit into Hungary and then apply for asylum. But as far as we know, this has not been granted yet to anybody. And so with this clear, even the most extreme measure, the European Commission had launched again a new infringement process on the 30th of October against Hungary. But this is not the first one. It's the 5th one on just asylum issues since 2015. And beyond these infringement measures that the Commission has taken, there's been, of course, a high number of preliminary reference requests made by Hungarian judges in mostly cases that are represented by Hungarian Helsinki Committee attorneys. These judgments and these ongoing infringement procedures show how important it is to trigger EU action to safeguard the right to seek asylum, and also the right to independent judicial decision-making, and also the right to effective remedies. And we do see very important landmark judgments coming from the Court of Justice that result from Hungarian cases. One that I would mention here is from 2018. It's called Torubarov, which concerned a Russian asylum seeker. And the court made it clear that under the charter, the right to an effective remedy means that judicial decisions will eventually should eventually pronounce themselves on the merit of asylum claims. And administrative authorities can't just play a ping pong and forever drag on an asylum case. And of course, the transit zone decision from May of this year was equally important. But it's important to see how these very important legal processes and actions by European institutions have not been, of course, able to stop the Hungarian government from going ahead and being basically the worst of the lot. In this regard, the upcoming Migration and Asylum Pact and the discussions will be extremely important. I think we have to be very cognizant of the toxic position that the Hungarian government has taken and how it, without strong resistance from those who protect and deem important rule of law, this position could spread to other member states or the whole EU itself.
Thank you very much. Ms. Badami, you have called which I find quite remarkable or memorable, the Hungarian government, the worst of the lot. Speaking of that, Ms. Kalin, Germany has been another of the countries at the center of the European dialogue on refugees and migration. How is the situation for refugees there at the moment, and how has it evolved during the last couple of years, and where would you position Germany inside the lot, so to speak?
So in 2015, we've been praised all over the world for welcoming thousands and millions of refugees into Germany, because Ms. Merkel decided to say, okay, there is no way we can keep our borders closed if hundreds and hundreds of people are coming and reaching for asylum. So some say she opened the borders, but the borders were open. She just said, okay, we will accept these people, we will check their asylum procedures, and this is what now is called the welcoming culture of Germany, what we had in 2015. And so I think in these days we had a real welcoming atmosphere here in Germany. There were people welcoming people and at the railway stations with signs and hugs and warm blankets. But from then we took a hard path, I would say, because the numbers increased. So we had high numbers of recognitions in the asylum procedures in 2015-16 and also 17. First of all, because of a lot of Syrian migrants coming, and there were acceptance rates of over 96% from time to time. But since then, the laws have not changed, but how the law is seen through the courts and also through the German asylum authorities has changed. So from high numbers of recognitions for asylum seekers, we dropped back from the refugee status to subsidiary protection and sometimes even rejecting people. So now we are back on a recognition rate from, as I said, over 50% now to around 30%. And also the public has changed in the public view of migration. I think the public is still very divided. There are these people saying, yeah, we still need to welcome refugees here in Germany, we need to welcome them here, and the others which go the way Hungary did, and seeing Hungary as an example also for Germany, saying we cannot accept any more refugees, it's too crowded, we cannot do this to our administration ever again because it's just too much work, it's just too much for the country, we cannot take any more, we cannot accept more people to come here because it's not possible to integrate them. So our system still is working, because here in Germany we have a very solid solidarity system. For example, we take care of people, paying them money if they cannot work. So this is a high cost also if we say, okay, we accept people here and take care of them. So we have a huge discussion right now which way to go. And right now we're leaning more into this rejection way, I would say. So from the welcoming culture, we came to a politic now, or a decision taking through the German asylum authorities, saying, how can we prevent people from coming here and reaching asylum here, which is, for example, done through the Dublin procedure, still in work. So we say we are not the first country of entrance in the European Union. So the numbers we're trying to send people back to Greece and Italy are increasing. And the second thing is we are very hard working on ways to send people back to their home countries. I would say before 2015 and in the short year time after, we didn't send a lot of people back to their countries of origin, except from the Western European countries, like Serbia, for example. But we never sent people back to Ethiopia, to Nigeria, but now we're really trying to find ways to send these people back, and we haven't had that before. And one focus, for example, in my field of work is Afghanistan. We haven't had people sent back to Afghanistan, but now we can send back people to Afghanistan without any valid papers. So they just need to be brought to the airports and flown back to Afghanistan. This was not possible before if they haven't had any papers. So this is also a development I think is not the right legal way, because the focus now is not on integration, is on how can we get rid of people and how can we send them back the fastest way possible. This is also a problem because, as you know, Germany is now has the presidency of the Council in the European Union, and what we've experienced here and how the law is changing here in Germany now is also in a lot of ways in a new pact on asylum, because I can see the handwriting of the Ministry of Interior Affairs here in Germany, and they are sometimes copied into what is now in the new deal of asylum, but we're going to talk about this later, I suppose. So I think the situation has changed a lot. We will see how it evolves, but I'm very skeptical that it's going to be in the favor of the asylum seekers. As far as my work as an asylum lawyer, I have the same problem we see on the Greek islands, that when I've started working, or when we started working with this high number of refugees, we could talk to them before the hearing in the asylum procedure. And this was so important because we explained them what is important in your case, what do you need to present, where is the focus. And now we nearly don't have access to asylum seekers anymore before they have their interviews, because they reach Germany, they are brought to closed camps where we nearly don't have access, so we don't know when are they reaching, where are they from. Then they have their interview maybe after 1 or 2 days, and then they get the decision after a few days later. Yeah, so we have a lot of people coming to us and they have a decision. They just reached Germany a week ago, so they haven't had the time to come down, to think about what is important in their case, and we just get these cases after they've been rejected already. So our only way to get protection for these people is through the courts. And so a lot of work which should have been done through the asylum authorities now ends up in court. So I sometimes have the situation that I have to do a new hearing with a judge in court who is not trained, who has no experience in the country where the person comes from, who has never heard of circumcision in Sierra Leone, but now has to take a decision on this case. So this is really hard, and this makes my work as a lawyer really hard, because I think it would be so important to talk to people before they apply for asylum, before they have to hearing, and this is now nearly not possible because of the changes we had here in the German law system, that people are taken into camps, and really close camps sometimes, so we don't reach them before they have the procedure, and we are just the ones cleaning up after the mess in the asylum procedure. So we have also this focus on speed, which I can just say this is something I don't understand, because we had this procedure. We were saying the procedure are taking too long if people had to wait for years and years. But now to do the whole asylum procedure within a few weeks is just not fair, and it's not. I think it's just not legal, because you don't give possibilities to reflect, to present your case in a good way. So this focus on speed is something we also have in the new pact on asylum and the new pact on migration in the European Union. And I think we need to take our time. It doesn't have to take years, but it should be worth to think about giving a few weeks, maybe a month or maybe 2, so people can come here, feel safe, come down for a moment, think about the cases, and then present the cases. Because I also have the experience, if there are these rushed cases, people they don't feel safe, they don't feel taken seriously, and they are not taken seriously because they just numbers, but they're not humans anymore. So this is something we really need to talk about, and this really has to change. This focus on speed cannot be negatively for the people reaching for asylum, because as we said, it's a question of life and death in some cases.
Thank you very much. Ms. Kardin, what really struck me in the way you described what happened in Germany in 2015 and the so-called German welcoming culture that was cheered all around the world. Maybe this welcoming culture was just about upholding the rule of law and not, there wasn't much more to it, really. And I think it's really, it shows us in what a worrying position we are in if this welcoming culture is now seen as a problem. And indeed, one of the first thing refugees get in touch with in the European Union is the law. As you have pointed out, from the moment they enter the Union, they are subject of a legal process examining their status. This means that access to justice is fundamental for refugees, but providing this access is now largely something non-governmental actors do, like European Lawyers in Lesbos, for example. And Mr. Worthington, I would like to ask you, why is it a problem if access to justice, access to legal counseling, and providing that is left to non-governmental organizations? Why would it be better if the states actively provide refugees with legal assistance?
Yeah, thank you. That's a good question, and I think that there are two parts to it. I mean, first of all, why is legal assistance right from the beginning important, and why should this be provided by the states rather than non-governmental organisations? I mean, I think as Ms. Carlin explained, that the having access to legal assistance right from the beginning is critically important, and I actually think it's critical for two reasons. I mean, first of all, and most obviously, for the integrity of the procedure, for the ensuring that the correct decision is reached in the end, ensuring that people understand the procedure they're going through, understand their rights and their obligations, and so are in a position to articulate their case in a way that actually reflects their need. I think it's almost impossible to overestimate the lack of information that people have when they arrive on the Greek islands. And of course, that's no criticism of them at all. I mean, I can't imagine how I would feel to suddenly arrive in Afghanistan and be told I was going through a legal procedure where everything was in Dari and I didn't understand a word of what was going on. I just arrived and I was told that my interview was in a couple of days. I mean, to expect people to be able to be in a position to articulate their case in that situation is, I think, frankly unreasonable, given that in that scenario, people's first and overriding concern is, of course, where am I sleeping tonight? Where do I get food to eat? Where are the toilets? Is this place safe? Rather than being in a position to comfortably articulate their case. So I think exactly as Ms. Carlin said, the importance of giving some time to allow people to settle, to speak to a lawyer critically, and to be in a position to articulate their cases is critical. And of course, the role of the lawyer in this is absolutely fundamental, because the asylum procedure, like any legal procedure, is complicated and has applicable criteria that people need to meet, and often they may not be what people who approach this, who arrive without understanding the asylum procedure, it may not be what they initially think. I mean, we have seen many cases of people who have arrived here on Lesbos, and they consider that it's an administrative process. They're unaware that there are certain criteria that need to be met because this has never been explained. Many people think that the best thing to do in their interview is to talk about the economic benefit that they will bring to the country. Often aware that Greece over the last few years has suffered some economic hardships, that many people think that the most important thing to demonstrate in their asylum interview is that they are, upstanding members of the community who contribute effectively to the economy, which, of course, from an asylum perspective, is the worst thing that somebody could say, but is a logical thing for somebody to say if they don't know anything about the procedure. And often people won't articulate their experiences, either because they don't feel comfortable to do so, and often the event's very traumatic and difficult to talk about, but also often because they think that actually Greece, the European Union, won't want to admit somebody, who won't want to give protection to somebody who may be vulnerable, who may have gone through traumatic events. And so I think that even that small amount of assistance that can be provided is very valuable. I think the other point about the importance of legal assistance actually goes to from the perspective of the state. I think there is an expectation, a narrative that legal assistance is only for the benefit of the asylum seeker. And of course, it is absolutely for the benefit of the asylum seeker to speak to a lawyer. But it's also, and I'm convinced of this after having spent 4.5 years on Lesbos, it's also in the benefit of the state that asylum seekers get to speak to a lawyer. This is because an asylum seeker who has spoken to a lawyer, who's been prepared, who has their case ready, who has all the evidence and is prepared for the interview, will go to the interview and will articulate their case. And it makes the decision-making process from the state's perspective both easier and quicker. And that applies for asylum, it applies equally for family reunification too. And I think in the long term, overall, it actually makes the process quicker to give people a bit more time to speak to a lawyer rather than rushing people through the process. And that's because whilst, as Ms. Carlin mentioned, it may mean that people get a decision within a week of arriving. In many cases, I imagine that those decisions will be challenged, that there'll be appeals, many will be overturned, and actually that makes the process longer rather than simply giving people a bit more time to speak to a lawyer at the beginning and having critically a framework in place for people to speak to a lawyer to avoid people being rejected incorrectly and unnecessarily and then having to go through the whole appeal process and the added administrative burden of that. And I think that leads on to the one of the fundamental reasons as to why we consider that this should be the role of the state rather than the role of NGOs, because ultimately this is a rule of law issue. We believe access to legal assistance is a fundamental right, and that everybody who arrives and applies for asylum should be provided a lawyer, free legal aid, right from the beginning by the state, in order to help people through the process, as I mentioned, for the state's benefit, but also fundamentally to ensure that it's for the asylum seeker's benefit, that the procedure is fair, robust, efficient, and that ultimately the rule of law is upheld and human rights are protected through meaningful access to legal assistance and meaningful access to justice.
Thank you. And obviously in lieu of meaningful legal assistance from governments, it's absolutely fundamental that there are non-governmental organizations like yours that take their place in some way. Ms. Carlin, your take on that?
I just wanted to add, because we have a funny discussion right now in Germany, because the German Asylum Authority now is installing a way of giving first consultation to the asylum seekers. So they do this kind of state consultation you're asking. So I totally agree on what you've said. There should be legal assistance, but what they're doing now in Germany is they give general information on how the procedure works, which is fundamental, but it's not the way I think asylum seekers need legal advice. And what is happening right now, the NGOs giving the legal assistance right now in the camps, they are expulsed sometimes, or they're cutting down their money, because they're saying now there is this assistance through the state, through the German asylum authorities. So this is also something which is not working. So we need to make sure that there is an independent legal assistance focused on the individual cases. So I'm just saying, just giving the state the obligation or giving the state the responsibility for consultation is not the way we want this legal assistance to be happening. So this is just to add on how it's working in Germany, because we have this discussion right now that the state is saying, okay, we're going to prevent this kind of assistance, but it's not the assistance we need for the asylum seekers.
Thank you very much. Mr. Worthington?
Yeah, just to quickly add, I mean, absolutely 100% agree, of course, that the critical element in this is I suppose the words meaningful and independent, that having a mechanism where people actually can't meaningfully access legal assistance, and if that legal assistance isn't absolutely independent, then that's worse than no legal assistance by the state at all. So yeah, I completely agree.
Ms. Padavi?
Under the Hungarian system, there is state-funded legal aid available to asylum seekers, but in fact, it is in no way meaningful. One very important aspect of any legal aid system is that it should be accessible and effective. And that part of that is that clients should be able to trust and communicate with the state legal aid personnel. In the Hungarian system, before the transit zones were abolished, there was a few state-funded attorneys who would provide legal assistance to asylum seekers. And of course, the Hungarian Helsinki Committee has attorneys who are contracted on a very long-term basis through our UNHCR-funded legal assistance and advocacy project. But asylum seekers always, in the past few years, had the chance to consult legal aid attorneys. And at the same time, we sadly saw that the effect of these consultations or even representation was made not much of a difference to the asylum seeker's case. Asylum is a highly technical legal field. This is why it's so important for asylum seekers to have lawyers who will explain the process. And particularly in a situation of unlawful detention, very quick procedural deadlines, notions such as the Hungarian invention of the safe transit country, which is also, of course, has been shown that by the courts of justice to be unlawful in the way it was applied. But these intricate legal procedures and notions require legal expertise in this particular field. And there was no criterion for state-funded legal aid lawyers to be in any way familiar with this legal field, nor was there any effort made by the state itself to ensure that clients or potential clients would have confidence in these legal aid lawyers. At the same time, what we saw was that the legal work performed by quite well-trained asylum lawyers that the Hungarian Helsinki Committee has been working with for many years was effective. And people really appreciate the fact that there are lawyers working with interpreters, and this is also extremely important, who will help them. And so we have seen over the years that cases represented by Helsinki Committee attorneys were quite successful. The asylum authorities' quick and I must say, very often very shallow decisions were overturned by courts, and the mere fact of an effective legal assistance annoyed the Hungarian state. And so over time, there were a number of measures taken to make it even more difficult for asylum seekers to meet with people who would be who would know this legal field. This was the first step was in 2017 in the summer, when the cooperation agreements that the Helsinki Committee had with the Immigration Office and other law enforcement agencies that allowed access for legal assistance purposes to detention centers, these cooperation agreements were terminated. This, of course, came amidst a huge harassment campaign against civil society organizations working in the field of human rights in Hungary. And then in 2018, a year after, the so-called Stop Soros legislation package also criminalized the assistance to people for the purpose of them filing an asylum application. The legislation probably deliberately was extremely vague, and for a very long time it was unclear whether lawyers would be able to continue to provide legal assistance, something that even the Hungarian Bar Association pointed out is completely with disregard to the basic right to have access to an attorney of one's choice. Of course, then there was another infringement process launched by the European Commission on account of this criminalization of humanitarian and legal assistance in Hungary. But at the same time, this was very clear that there was a campaign against people and organizations who are willing to put, professional efforts to assist people with their right to understand a legal process. And I think we really have to be very wary of the narratives here too, where lawyers are singled out in media, or even judges are singled out in what has happened already in Hungarian pro-government media for turning to the Court of Justice to asking it to clarify EU law. So the restrictions on access and effective access to legal assistance are part of a campaign, I think, to really restrict the right to seek asylum. And we have to be very much aware of the need to work with other lawyers too, not beyond the asylum field, to ensure that they also stand up for the right of people to have legal representation, no matter what field this concerns.
Thank you very much. The European Commission has proposed a migration package to address multiple issues of the current European migration system. Ms. Padawi, what are the EU's plans and how do you evaluate them? Will they be able to bring Hungary back into the EU migration system that it removed itself from?
Human rights and refugee rights advocates have been waiting for the EU Migration and Asylum Pact with quite a lot of concern. At the same time, for somebody from Hungary, like myself and my organization, this is a real dilemma. Hungary has been, through the past years, has really put itself out of bounds beyond anything that is currently permissible under the common European asylum system. And therefore, looking at the pact itself, we see that from a Hungarian perspective, some things would need to improve if the pact's rules were adopted. These very same rules might seem extremely alarming to many refugee rights advocates around Europe. But when it comes to reinforcing the basic notions of detention, which must be ordered by law for a definite period of time, having seen how there was automatic detention indefinitely in the Hungarian context, we have to welcome the fact that in many points this would be made very clear by EU law that detention must have legal grounds and there are limits to it. At the same time, looking at the question of access and how access has been unlawfully and arbitrarily limited, eroded in Hungary, we're also a bit positive about the fact that there is spelling out that asylum seekers still have access to protection in Europe. However, of course, the devil is in the details, and these details provide a pretty narrow opportunity and rights to asylum seekers. But I must say that it's difficult to look at this pact as inherently and overall negative from a Hungarian perspective, because the current practice and the current legal framework in Hungary is beyond what even the new rules proposed by this pact would allow.
Thank you. Mr. Worthington, you have told us that procedures are getting ever more swift on the Greek islands, and I think that the new proposals by the Commission are designed to make asylum procedures and everything that's connected to it more swift. So what's your take on the recent proposals?
Yeah, thank you. Exactly. That was exactly our analysis of the situation, that almost the situation on the Greek islands is what the pact will look like when it's in force. This emphasis on really quick procedures, it's almost like this is a preview of what the aim of the pact is going to be. And I think there are two primary concerns for us. I mean, obviously, until the legislation goes through, it's difficult to see all the elements, but I think the two main concerns are exactly as you say. Number one, the speed of the procedure. The pact seems to emphasize having a very quick procedure, and as we've seen and as we've discussed, that has many major concerns from the rule of law and access to justice perspective. Similarly, the pre-screening regulation, which again goes to this issue of speed, and it's something that struck me, that having worked on Lesvos, where there are people from many different nationalities going through the procedure, I think that often people think, oh well, it's Syrians and people from Yemen who need access to legal assistance and will need support through the procedure. And whilst that is absolutely true, and everybody should have meaningful access to lawyers, it's often people from countries of lower recognition, average recognition rate, that actually where the impact of meaningful access to legal assistance is so profoundly clear. For example, a member of the LGBTQI community from Cameroon, and Cameroon is a much lower recognition rate country than somewhere like Syria or Yemen, obviously, but a member of that community coming from Cameroon, in many cases, really does face significant persecution and is at serious risk. But look simply at from a perspective of average recognition rate, Cameroon is a lower recognition rate country, and so that suggests that therefore they would go through or potentially go through a fast track procedure with even less opportunity to speak to a lawyer. Whereas actually, it's in cases like that where having the proper opportunity to speak to a lawyer, to have the opportunity to speak to a lawyer and have numerous consultations, really go through the case, prepare the case, prepare the applicant, gather the evidence, is where we see that a critical difference can be made in certain circumstances. So in some senses, from an access to justice and a rule of law perspective, this pre-screening regulation is almost upside down, because it has the effect of further denying access to legal assistance from people from low recognition rate countries, and often it may be people from those countries who actually could really benefit from that opportunity to speak to a lawyer.
So after everything that we've talked about, is there such a thing as the rule of migration law in the European Union? That's something I would like to ask the three of you. Ms. Carlin, would you like to start?
So from my point of view, I don't see really a big change. I just see things getting worse, which is very funny, because from the Hungarian point of view, it's getting better. From the German point of view, we would say it's getting worse. And we were hoping for bigger changes in favor for the migrants. And right now it's just, as we've heard, speeding up the procedure. It's not guaranteeing an efficient way of legal protection and support. And we were really hoping, for example, to get a new way of fair share, which is not happening, because still we have the main responsibilities in the countries at the European borders. So this is not changing through the new pact. So I don't see that there is a change, but I think right now is also not the time, because as we have seen, there is not the will of the European countries to work together to find a fair and, I would say, constitutional way of finding a European asylum system. So there are so many countries rejecting for example, to accept a fair number of refugees. Other countries would accept refugees, but say if the other countries don't work and don't cooperate, why should we take on more refugees? So there is just not a solution right now. So we will have to wait what the future brings, and I'm just hoping that we will stick to the fundamental human rights and we will find our ways, and if it's necessary, through the courts, because this is the only way we have as lawyers, and this is what we're all working on.
Thank you. Ms. Padavi?
I agree with Ms. Carlin absolutely that the courts are essential in upholding safeguards, and I think a lot of our energies and commitments should be concentrating on this. Sadly, I have to agree that those who are the most vulnerable and those who need the most help, those who well-functioning legal aid systems should be really prioritizing, are probably going to be again in the weakest position. And so a general strengthening of standards for everybody is probably not going to be enough, and a lot of attention and legal work should be concentrated on helping to reinforce the rights, the effective rights of the most vulnerable in this. I find it extremely concerning that the Hungarian government, under its latest rules on this embassy system, would allow even the detention of unaccompanied minors under the age of 14. There is no special provision even for children, and this kind of actions and policies we really have to push back against. At the same time, I think that there is a lot of faith to put in the legal profession, attorneys and judges. And we have seen in the extremely difficult, polarized, politicized Hungarian context how judges themselves, who have not worked on asylum issues for a very long time, have recognized that extrajudicial arbitrary measures are not permissible neither under Hungarian nor European Union law. And they found this field to be not only intellectually stimulating, but something that is a core rule of law issue. Many of them have recognized this and see that there are still safeguards and opportunities afforded by EU law, and these are being developed at the Court of Justice now. So I think all eyes should be on Luxembourg, and we have to use the case law, we have to use the charter to reinforce these rights. And this is quite instrumental, and this is a very strong link to the rule of law debate.
Thank you. And Mr. Worthington?
So the question, is there the rule of law in relation to asylum law in Europe? Well, I think that yes, but it's a fragile flame and it needs protecting in this current situation. What really strikes me is that it seems to have now become accepted across Europe that there'll be, for example, tens of thousands of people, tens of thousands of asylum seekers living in refugee camps on the Greek islands. And this is something that 5 years ago would have been absolutely unthinkable. But now the situation has become normalized. And I think that looking at this from a Greek perspective, maybe something that has a theme that has gone through all of this discussion is that this is not just a Greek issue. It's a European issue and needs a European response. But this, to have a European response, needs the will and the agreement of the EU member states to work together and to share responsibility. And I suppose right now this looks quite difficult, and so needs the active work of organizations, of lawyers, of judges, politicians and citizens across the EU to actually ensure that this flame of the rule of law when it comes to asylum law is protected in these difficult times.
Well, thank you very much, Maria Carlin, Phil Worthington, and Marta Padavi, for joining us for this episode on refugees and migration law and their relation to the rule of law in the European Union. And thanks to all of you for listening. We appreciate your feedback with the hashtag #LawRules and on Verfassungsblog, and hope that you will listen to us again next week for our 10th episode on the European Charter on Human Rights, the European Court of Human Rights, and the Venice Commission of the Council of Europe. This was We Need to Talk About the Rule of Law. See you next Wednesday.